Imagine you are walking home one evening, and suddenly the police arrest you. You do not know why. You are taken somewhere. Days pass. No one tells you what you did. No lawyer is allowed to see you. No court is informed. This is not a fictional scenario from a dystopian novel. This was happening to people in India before the Constitution came into force. And it continues to be the risk that Article 22 is designed to protect against. Article 22 operates on two completely different levels, and it is essential to understand both clearly because they create very different standards of protection. Level 1 is ordinary arrest under Clauses 1 and 2 of Article 22. When you are arrested for an ordinary offense, three specific rights kick in. Right 1. You must be informed of the grounds of your arrest as soon as may be. Not maybe. Not when convenient. As soon as may be. Right 2. You must be given the right to consult and be defended by a legal practitioner of your own choice. Your lawyer, not one chosen by the government. Right 3. You must be produced before the nearest magistrate within 24 hours of your arrest. This 24 hours excludes the time needed for travel from the place of arrest to the court. After 24 hours, the magistrate must authorize any further detention. The police simply cannot hold you beyond 24 hours on their own authority. These three rights are strong protections against arbitrary arrest. They give you information, legal help, and judicial oversight within a very short time. Level 2 is preventive detention under Clauses 4 through 7 of Article 22. Preventive detention is fundamentally different from ordinary arrest. In ordinary arrest, you are detained because you have allegedly committed a crime. In preventive detention, you are detained not because of anything you have done, but because the government believes you might do something harmful in the future. You are being detained to prevent a future act. No charge. No trial. Just the government's assessment that you are a potential threat. Article 22 Clause 3 makes clear that the protections of Clauses 1 and 2 do not apply to enemy aliens and to persons detained under a preventive detention law. This means if you are under a preventive detention law like the National Security Act, you do not automatically get the right to be produced before a magistrate in 24 hours or the right to a lawyer of your choice. The Constitution does impose some safeguards on preventive detention. The person must be informed of the grounds of detention as soon as may be. However, the government can withhold grounds that it considers against public interest to disclose. The person has the right to make a representation against their detention. If the detention exceeds 3 months, the matter must be placed before an advisory board. The advisory board consists of persons qualified to be appointed as high court judges. If the advisory board finds there is no sufficient cause, the person must be released. The most disturbing fact about Article 22 is that it embeds the power of preventive detention without trial, within the Fundamental Rights chapter itself. The Constitution authorizes this extraordinary power because the framers believe that in a country facing partition violence, internal security threats, and external aggression, the state needed this power as a last resort. But it has been substantially abused. Preventive detention laws like the National Security Act, the Unlawful Activities Prevention Act, and various state laws have been used against political dissidents, journalists, and activists. The ADM Jabalpur case of 1976 during the emergency represents the ultimate abuse. The Supreme Court majority held that even habeas corpus, the most basic right against illegal detention, could not be enforced during an emergency. This was later overruled by the Puttaswamy judgment of 2017. For your exams, remember this fundamental distinction. Ordinary arrest equals 3 rights, grounds, lawyer, 24 hours to magistrate. Preventive detention equals much weaker protections. Some grounds may be withheld, no 24-hour magistrate rule, advisory board review after 3 months. Article 22 Clause 3 is the provision that creates this two-tier system. Now your MCQ. Under Article 22, which of the following protections does not apply to a person detained under a preventive detention law? Option 1. The right to be informed of some grounds of detention. Option 2. The right to make a representation against the detention order. Option 3. The right to be produced before a magistrate within 24 hours of arrest. Option 4. The right to advisory board review if detained beyond 3 months. Think carefully. The correct answer is option 3. Article 22, Clause 3 explicitly says that the protections in Clauses 1 and 2, including the 24-hour magistrate rule, do not apply to persons detained under a preventive detention law. Options 1, 2, and 4 are all protections that do exist under the preventive detention provisions of Article 22, Clauses 4 through 7.